Hi, I'm Louisa Sijabat, a liquidator and bankruptcy trustee. Today's question is, what happens if a deceased estate is insolvent? That is, there's more debts than assets. Can you have a bankrupt deceased estate? The answer to this question is yes, you can. There are two main situations or ways of dealing with an insolvent deceased estate. Firstly, is under the state and territory probate laws. So for example, in New South Wales, the Probate and Administrations Act. Alternatively, you can go down the bankruptcy road and have a bankrupt, insolvent, deceased estate. Now, if you are going down the bankruptcy road, either the person administering the estate or a creditor can apply to the court for the deceased estate to be declared bankrupt and administered under the Bankruptcy Act. Now, it gets quite technical from here, and it's definitely worth legal advice as to which road to go down, the state or territory probate laws or the bankruptcy road. But the answer to this question, in short, is yes, you can have a bankrupt deceased estate.